Yeah, I realize that there's a number of ways consumers get deceived and ripped off. In the practice of civil racketeering, you have the opportunity to look a little bit deeper into what's going on in order to create a maximum result for yourself and your case. The way about that is identifying the issues with someone that knows what they're doing, as well as getting into all of the facts, all of the documents, and everything up front. Because when you have the information to prosecute a civil racketeering case or even a consumer protection case, you have the ability to get something resolved, because that's what we're all looking for. And what my firm is looking to do is take a deeper look into a fraud case to see if I can identify these criminal predicate acts to form the basis of civil racketeering. Because if you get there, your damages can be threefold, times three, and your attorney's fees. And I think that is something that I hope all consumers can take a look at. And if they've been aggrieved, they can see about investigating a civil racketeering case.
Hey guys, I'm bringing to you today Jay Farrow, Farrow Law. Jay has been practicing law for the past 17 years. He has a very interesting and unorthodox approach to consumer complaints. Typically, we hear very often from consumers, hey, this is a class action, this is a class action, I gotta run a class action here. And Jay came to us, he runs a practice of civil racketeering cases. So I will let Jay speak for himself and talk about it. Please tell us, what do you do?
Well, first, thank you for inviting me for this interview, and I appreciate the opportunity to talk a little bit about my practice and some of the unorthodox things that we do. I actually started my practice, my career, I should say, in the state attorney's office in Miami-Dade County, and from there, I left that and went to practice in the area of franchise law, representing the franchisee side against the big bad franchisors. After that, I represented some bankruptcy trustees in bankruptcy, and I did a bit of construction litigation. But in that bankruptcy practice, I was able to learn how to chase dirty money, because when you represent a panel Chapter 7 trustee, part of your job is to bring money back into the bankruptcy estate. And a lot of times what happens is that people fraudulently transfer that money to family members. And in 2008, I opened up my own practice, generally representing foreclosure clients, where the bank or whoever that was at the time was going after homes for foreclosure down here in South Florida and throughout the state of Florida. And so, again, another David versus Goliath story, where my law firm was representing the little guy, so to speak, against the massive frauds that were happening in the banks and also in the law firms down here in South Florida that were prosecuting those cases. And in about 2015, 2016, we started to branch out into prosecuting actions for violations of the Fair Debt Collection Practices Act, as well as the Florida Consumer Collection Practices Act. We started to branch into this area of civil racketeering. And most people don't understand what criminal racketeering is, let alone civil racketeering. And I know that your customers and your viewers are consumers that have been defrauded or aggrieved, and they're looking for some answers. In our practice, we use civil racketeering as a tool to prosecute the people that are working together to rip people off. And in layman's terms, that's the best way for me to explain it. When you have an individual or a group of individuals that have a pattern of activity that's fraudulent, that's one of the steps into civil racketeering. Then you have to identify what's called criminal predicate acts. And most of the time, as it relates to many of your viewers, is going to be where a piece of email went out that contained fraudulent information that was relied upon to defraud. When you have more than two of these predicate criminal acts within 10 years, you can file a case for civil racketeering, assuming that your viewer was actually hurt by the racketeering activity. And civil racketeering in general was really an exercise of allowing prosecutors to go after the big fish, to go after the kingpins of of large organized crime families. And I share with my clients, it's as if our law firm prosecutes organized crime in civil court. Now, in civil racketeering, there's no criminal component. So maybe some people get confused with that. We're actually not prosecuting anybody. Nobody goes to jail. But here's the interesting thing about civil racketeering. The statute itself, both the federal and the state in Florida, provide for what's called treble damages. And this is where civil racketeering statute starts to diverse a bit more than most of the consumer protection statutes that many of your viewers might be aware of. In Florida, our main one is called Florida's Deceptive and Unfair Trade Practices Act. And under that statute, a consumer is entitled to their compensatory damages and their attorney's fees. If you have identified that there is a deceptive practice or an unlawful activity, taking a step forward and see, did anything fraudulent get sent in an email in this transaction? Did it get sent in the mail? Are the people that are working together shifting money or clients' money from one bank account to another bank account in order to hide it or hide the profits? If you start to dig deeper into a consumer protection case, there's a possibility that you might find racketeering activity. And if you do, the benefits are huge, because not only do you get your attorney's fees if you win the case at the end of the day, but you also get 3 times the amount of your compensatory damages. And that's what makes it very attractive for a couple of different reasons. One of which is, if this is on the table, the chances are better for you to settle the case as opposed to 2 to 3 years litigation. You had mentioned like our unorthodox practice methods. Well, I believe in gathering information before a case is even filed. I believe in using experts and even ex-CIA, ex-FBI. I work with a former federal prosecutor to make sure that we have our story dialed in before we even file the case. And in many instances, we serve the other side with a pre-suit demand and invite them to mediation or to resolve the case. And in many cases, that happens. See, I don't think that litigation serves anybody, because as many of your viewers might know, if they're going through it right now, the process takes forever. And in during that process, that business can go on operating as it were. In most of my cases, many people have been ripped off, and a lot of people know information. So one of the other unorthodox things that we do is that we send out notice to witnesses. And we make videos, and we also have releases that go out in another iteration. And we ask the public to help us, if they have any information, to give us, so that way we can prosecute our claims. So it's not an easy statute to understand by any means. But once we've been doing this for a while, I mean, it becomes like second nature. And plus, we work with some professionals that prosecuted civil RICO cases for over 20 years in federal court out close to the District of Columbia, Washington, D.C. If you get the components, and a lot of your viewers are like, okay, well, how do I start checking the boxes? Well, the number one thing is look at all of the documents that you have, all of the contracts, everything that was sent to you in an email or the mail. And if you can look into that and start seeing, well, that thing that they said here wasn't correct, or that number like that they're asking me for in the contract is not what we negotiated, and the invoice is wrong, you can start picking up your ear a little bit and saying, okay, let me dig a little bit further. I get one of the questions that I get asked a lot is like, what does someone do when they feel like they have a civil racketeering case? Number one, I tell all my clients this: write down everything that happened to you. Whether you're in a civil racketeering case or a deceptive practice case, write down everything that's happened to you in a narrative, and give that to the lawyer. But ask questions when you're hiring the lawyer. What experience do you have in this area of law? And when you're dealing with civil racketeering, it's a whole new ball game other than just consumer protection. So if you're interested in civil racketeering, make sure that your lawyer has that experience to handle a case like this.
Arbitration in the contract very often precludes from class actions going forward. A consumer very often signs a piece of paper, terms of service, whatever that might be, that agrees to arbitrate before class action get settled. Is my understanding correct that civil racketeering is actually the way to go around it? Because if the consumer has been defrauded to the point of racketeering, and that can be proven, you can actually go around that arbitration provision.
We get this issue all the time, and one of the arguments that we have, and we put them into the complaint, is that the arbitration clause or the contract itself was procured by fraud. In other words, the actual agreement was drafted just that way, knowing that they were going to steal from a consumer or from an employee. And as a matter of fact, we're about to go to arbitration in the case because the judge didn't see it our way as far as the allegations in the complaint. But the key is this: if the arbitration clause itself was put into the contract for the purposes of fraud, in other words, to make it so ultra expensive for the consumer to handle that, and it falls into all of the other civil racketeering elements, then you can circumnavigate. And I've come to realize that filing a lawsuit like this, I don't need the breach of contract action anymore. And the breach of contract action brings the contract in, and then most judges, as you know, if you've been through this process before, most judges like, oh, arbitration clause, go to arbitration. And that's basically what the law of the land is. But yes, this is a way to, if it applies, you don't just put something in a complaint because it's nice to say. If it's accurate, and in a lot of cases, every single component of the person's business is for the purposes of defrauding the consumer or the employee or the end user of the products. So yes, so the simple answer is yes, we get that all the time, and they try to compel arbitration all the time. Sometimes they win, but we're getting better at identifying the actual component of fraud in the arbitration clause and circumnavigating that outcome.
Thank you, Jay. Thank you very much. So in our initial meeting, you've mentioned that this field of civil racketeering is very scarce in United States civil practice, law practice. Why do you think that is? And I believe you expressed the desire to actually expand on that field, and you would welcome to see other attorneys coming in practicing this side of the law.
It's a matter of the unknown, and most lawyers behind closed doors might tell you this. Whether it's going into personal injury, if it's going into bankruptcy, or going into civil racketeering, it's like a new world. And civil racketeering is a complex statute. I'm not going to call it disfavored, but courts look at it with an eye like, all right, I see what's going on here. You're saying the word civil racketeering because you want to be inflammatory and you want to get the other side to settle. Well, we're not going to go for that right now. What I'm hoping to do is to create a practice that people look at my pleadings, they'll see how carefully we put in the facts that we've received from our client and the documents or the experts, and we put that in very particularly so that way when a court looks at this is not just a civil racketeering and nothing to it. This is a dyed-in-the-wool, well thought out, well reasoned and researched complaint. But it's a difficult field to get into because these cases are expensive. All right, to be able to prosecute because there are multiple people. A lot of times in my cases, I have more than 15 defendants. But I believe, though, that the expensive litigation can also be circumnavigated by having the information that if the other side knows that we have, they're like, let's just get rid of this thing. Because nobody likes to have this stuff out, knowing that because they have other victims. Look, most of the consumers out there that have grievances, you're not the only ones. You're not the first one. And so the issue with civil racketeering is it is complex and it can be expensive. But if you know what you're doing, you know what to look for, that limits the amount of work that you need to put into these things.
Jay, thank you very much. If one person comes to you with a company XYZ that they had a particular problem, would you be looking for other consumers that possibly suffered the same fate, or you would be satisfied with just one plaintiff to take it forward?
I'd be satisfied with one or many, but your question brings up an interesting distinction about civil racketeering. In civil racketeering, I'm not actually chasing the corporation. Corporations are just people. It's the people that are running the corporations with a couple of other people. Usually there's a kingpin, just like a mob boss, and then you have everybody else doing what the kingpin says to do, and they're making money off of it. So the other distinction of civil racketeering, I don't think I made it clear earlier, is that unlike consumer protection, I'm not going after the company. I'm going after the enterprise that's being worked with the people acting in concert together. So the element of personal liability exists in these cases, whereas in most consumer protection cases, unless you have a corporate veil, I'm going to breach the corporate veil, it doesn't exist.
If we have a viewer right now watching this video who thinks that they have a valid civil racketeering case, what information shall they know? How shall they contact you? And how much shall be they expecting to pay?
And as I shared with you in our first meeting, is that most of my cases, there's a lot of money at stake. So before you're going to think about engaging the statute, really check in to find out what exactly happened here. Now, there is class action civil racketeering. Every client's going to be different as far as what the costs are, and what we do in our firm is a flat fee and contingency that makes it affordable for the client and also for us to be able to prosecute the case. If they wanted to get a hold of me, they could reach me at Jay at farrowlawfirm.com. And if they want just to write me an email about, setting up a consultation. And I mean, we believe in free consultations. I'll spend a few hours with the client just so they understand the legal landscape, because I think that's only fair. Because when you get into something like this, again, it's heavy-handed. When you're saying civil racketeering, everybody's ears picks up like, what is that? Racketeering. That everybody understands kind of what that is. And so when you're getting into this, if you have the case, and a lot of times once you put this complaint together, that's the painful part, and then you send it to the other side and they want to resolve it, because again, you've given them all of the information that you have. It's documents, it's statements, it's affidavits. It's not just the complaint that just says civil racketeering. But yeah, they can send me an email, and I'm happy to support them with any questions that they have.
Jay, thank you very much.